take a second to do. I think you all get a consent bubble on your screen. That might kick you out if you don't agree to go live. Sorry, not sorry. Close that. Great. So good afternoon, everyone, and welcome to another edition of Tenant Tuesdays at 2. It has been quite a while since we've joined your homes this way, but we are back to have a super important conversation about some recently passed legislation through Philadelphia City Council. This legislation will empower tenants in a very meaningful way, allowing them to kind of level the playing field as to how they are treated with landlords when they are seeking to enter new properties. We're talking about the Renters Access Act. And today I'm joined by Rashida Phillips, who's Managing Attorney of Policy here at Community Legal Services, and Holly Beck and David Wengert from the housing unit here. And we're going to have a very robust conversation about some exciting news in the world of Philadelphia housing. I think it's maybe a first of its kind Renters Access Act across the nation that really empowers tenants and limits the negative information that landlords can use when making assessments of them as prospective renters. So I'm going to turn it over to Holly to kind of get our conversation started and introduce the Renters Access, the Renters Access Act, RAA for short.
Thank you, Kadeem, and hello, everyone. I'm excited to be here with you all talking about the Renters Access Act, which went into effect in Philadelphia on October 13th. So it's brand new. And we have two experts here to talk with us today about what it means for renters, what folks should know about their rights and protections. So to start us off, Rashida, could you tell us a bit about the Renters Access Act? What is it and who does it protect?
Yes, thank you. And thanks for having me. So before I get into what it is, first, I'll just talk a little bit about the problem. What the Renters Access Act is meant to deal with is the issue of eviction records and how eviction records are used in tenant screening decisions. And so for a tenant who's going to apply for a unit, who may have encountered eviction court or may have dealt with eviction in some form or other, this deals with how those records are utilized and accessed in those decisions. And so when we took a look at this, and so we're at CLS, we're part of a coalition of advocates, people with eviction records who have been impacted by evictions, and other folks who have been looking at this issue. And a couple of months ago, we put out a report. And that report had some key findings about eviction records and just how pervasive this issue is. And so one of the issues with eviction records is that, first of all, they're extremely easily accessible. And so even in circumstances where we see that a tenant has won their case, where they've worked out an agreement, where the landlord might have withdrew the case, they may have walked out of the courtroom hand in hand, that case is still accessible. That eviction filing is still accessible very easily. You can just go right online, look at the website, type in a person's name and get access to that information. And so those court records are utilized in these decisions, again, regardless of the outcome of the case. And so those records continue into the far future to work to deny people access to housing. Another issue with the eviction records is that over a quarter of the eviction filings in Philadelphia from 2015 to 2020 did not result in a judgment against the tenant. And so in a lot of those cases, the filing was withdrawn or the tenant won their case. Again, even still, in over a quarter of these cases where people have had good outcomes from their eviction case, they still have that mark on their record that prevents them from renting in the future. We also have a gender and racial justice issue when it comes to eviction records and who gets those records. And so eviction records nationally and in Philadelphia comes with significant disparities. And so we see in Philadelphia that 56% of all eviction cases before the pandemic occurred in majority Black communities. 81% of those filings occurred in communities of color. 49% of those filings occurred in Black communities during a pandemic, and 78% of them occurred in communities of color during a pandemic. And we already know that there's significant racial disparities around COVID-19 and who was impacted and affected by COVID-19. And so right now we're seeing those crises converge around issues of racial justice. And again, the people most likely to be evicted are people who live in, who are part of the Black community, Black women and their children, and other people of color are most likely to be evicted. And so when you have a group of people who are most likely to be evicted, and who make up most of the eviction filings, those folks have records that follow them for life, because prior to the Renters Access Act, we do not have any protections in Pennsylvania or in Philadelphia that mask those records. A couple other facts to note about why we needed the Renters Access Act. Again, another issue with landlord-tenant court is that most tenants who show up to court do not have legal representation. So there's high rates of what we call default judgments, as well as just people who don't get a fair shake in court because they don't have legal representation, where their landlord is more likely to have legal representation. So prior to programs like the Philadelphia Eviction Prevention Project and what we'll see in a couple of months is right to counsel start to begin in Philadelphia. Only 5 to 8% of tenants got legal representation, while almost 85% of landlords receive legal representation. So again, what the outcomes are in court may not necessarily be fair or representative of who has access to the court to be able to have a good outcome coming out of court in a way that's going to make their record not look so bad when it comes to being screened for a landlord. And then the last thing I'll note about why we needed this kind of protection here is because landlords routinely rely on tenant screening companies, internet searches, and other methods to be able to readily access tenant eviction records. And often these landlords are refusing to rent to tenants with even just one eviction filing on their record, again, regardless of the outcome. And so in a lot of situations, tenants are not able to access their tenant screening report. They don't know, they don't know the process for being able to access them, and it's very difficult. And then once you do get a copy of that tenant screening report, how do you challenge that report, right? So there's really just a lot of challenges in terms of if you see any inaccuracies on that report, or it's just reporting things wrong, which these companies tend to do. If you have a common name and you end up with someone else's record on your report, all of those things, it can be really difficult to challenge. And so the Renters Access Act was really meant to address all of those things. It's a law that says that we need to regulate and look at how landlords are using eviction records in their tenant screening and make sure that it's fair. Make sure that these records are following people and being utilized for life, and just creating circumstances where people are in these sort of revolving doors of poverty, not able to access healthy housing, often for circumstances that are beyond their control, but even for people who, fell into hard times, fell into poverty for circumstances beyond their control. Even just a death in a family or falling behind on a bill, right, can put you in circumstances where you're facing eviction. And should these people be punished for life because they fell on hard times and somehow got an eviction record, right? So it's meant to address all of those things and just provide some balance and some transparency into what landlords are looking at when they're screening a tenant, how they're utilizing eviction records, making sure that they don't have these policies which disproportionately impact a certain group of people. If you have a policy that says, hey, one or more eviction record, I'm not going to look at your application, it may disproportionately impact people in the Black community who, again, are more likely to have these records. And so trying to also craft something that is meant to address discrimination that may be happening as a result of these evictions.
Thank you, Rashida. So if I'm a tenant in Philadelphia and I am starting a search for housing and I'm looking at apartment listings, what is something I should look for? And I'll toss that question to you, David.
Thanks, Holly, and thanks for the opportunity to speak. I would say that a tenant who is looking for housing should absolutely, before they apply for that rental property, needs to be asking the landlord for a copy of their screening criteria. So it's so important before you pay the $30, $35, $50, sometimes $85, $100 application fee, that the tenant have the opportunity to see, well, what exactly is the landlord screening for? What are they looking for? And that criteria that the landlord is using, that they need to now, as a result of the Renters Access Act, have written down, that criteria that they're using really needs to be uniform for all of their applicants. That is to say, a landlord can't give one applicant one set of criteria and say, if you have an eviction on your record, I'm going to deny you, and then get a different criteria to a different tenant and say, well, I'll let one eviction slide. No, you have to have the exact same criteria for all of the tenants that are applying, and you need to have them written down and provided to the tenant.
Thanks, David. So Rashida, if I apply for a unit and then my application is denied, what are my rights?
Yes, and sorry, I had a PowerPoint, but it's not working. I'll try to pull it up in a little bit. But yeah, if you are applying for housing, you went through that process that David just talked about, you've gotten your uniform screening criteria, you know that criteria that's on there is the same for every tenant who is applying for that building. You know, that criteria lists everything that's in a Renters Access Act that the landlord cannot consider or that they can consider, and then you still get denied. And so at that point, what the law says is that you have 48 hours as a tenant to notify the landlord that you're applying with that you intend to dispute the denial. So in addition, and also, I'm sorry, let me back up just a second to say that the landlord is also supposed to provide you with a written rejection letter stating why they rejected you. So giving the reason why they denied your application, as well as give you a copy of any third-party reports or information that they use to screen your application. And so if they used a tenant screening company, they need to give you a copy of whatever the report was that came back from that tenant screening company. If they went onto the municipal court website and just printed out your eviction case from the website, they need to give you a copy of that. So any information that they relied upon to screen your application, you should get a copy of that with your rejection letter. So you get that rejection letter, you say, look, you look at the documents that was provided to you, you see some errors, or maybe your circumstances have changed. Maybe you were evicted 3 years ago and eviction was based on, non-payment of rent, but you've gotten a new job since then, or your circumstances have changed significantly. So what you're going to do at that point is you're going to say to the landlord, hey, I intend to dispute this, dispute the denial. You have 48 hours to do that, and you can either do that in writing, or you can call the landlord and say, look, we advise that you do it in writing, but you can also call the landlord and give them that notice that you intend to dispute. And then within 7 business days from that period, from the time that you got the rejection letter, you bring back any information that shows, again, that either the records that they relied on or the information that they used was in error. They have the wrong name. It was not, the outcomes were listed incorrectly on the tenant screening report, which is something that we see very often. Or, as I said, your circumstances have changed. So it's not just if the records are in error, but also if you have some changed circumstances, what we call mitigating circumstances, as to why you would make a good tenant despite whatever your record may have shown about your evictions. So you take that information back to the landlord. The landlord has a couple of days to consider it, and the landlord can decide at that point whether or not to offer you the unit. If your information, again, is correct, or you're able to show mitigating circumstances, and the landlord owns more than 5 units, then the landlord at that point has to offer you the next available unit of comparable size and rental amount whenever it's available. So that's only going to be for landlords who own 5 or more units. For the smaller landlords, they do not have to make that offer of the next available unit. And also I want to clarify that, right, this process of disputing the record is not a court process. It's not a process where you want to have a third party like mediator or something like that. It's going to be a process that happens between you and your prospective landlord. So that said, we really advise people to make sure you have all your documentation, try to do things in writing as much as possible so that if there are any issues down the line, right, you do have some documentation that you went through that dispute process and that you gave the landlord the updated information about your situation. So that's essentially the process. And again, although the landlord who is a smaller landlord doesn't necessarily have to offer you the next unit, what this law does do, right, is that it allows you to get a copy of that tenant screening report, allows you to know what you're going into and what they're expecting when you're applying for a new place, right? And once you have that copy of that tenant screening report, you do have some other options besides just interacting with the landlord about getting those records corrected or disputing those records, which we can talk about or give more information about at some other point.
So I'm excited, maybe too excited about the fact that this legislation exists and what it actually does for tenant empowerment. So this is a question for either David or Rashida. Feel free to jump in. So day in and day out, we see tenants and they complain about being rejected by landlords. Is there anything that this act prevents the landlord from considering when looking at a tenant's application? So all four of us apply, we each live different lives. What can landlords not look at when they like consider me or Holly or David?
Well, I think the simplest answer to that question is that before this law went into effect, landlords could reject applications by basically saying, you don't hit this credit score, your application is rejected. Or landlords could say, you got one eviction on your record, or if anything comes up showing that you were in court, your application's rejected. And the Renters Access Act now makes that illegal. Landlords in the city of Philadelphia, by and large, all landlords with very few exceptions, are required to look at a person's application individually. They can no longer just take that application and say, I'm sorry, I see an eviction, 5-10 years ago. I'm going to another tenant. And I'm rejecting your application. So landlords really need to look individually at each application, and they cannot deny based on certain evictions, which I think is really important. They can't just say there's a single credit score that I'm going to deny based on, and they can't say any eviction and you're out. So which evictions are they no longer allowed to consider? And you can see here, Rashida, thanks so much for bringing up this slide. This is in that third bullet, you'll see a list of the items that the landlord can no longer consider when rejecting an applicant. So the landlord can't say, oh, you had a case in court, eviction case, it was withdrawn, but I'm still going to deny your application. No, the landlord still got to consider your application, can't use that eviction case that was withdrawn against you. Same with the case that was dismissed. Or, in some cases we've seen it, the tenant actually won their case in court. The court found for the tenant, but still that case is being used against them by future landlords who are rejecting their application simply because they were in court. You'll see the second bullet there. The case resulted in a judgment that's been satisfied or vacated. If that judgment's been satisfied or vacated, that means the tenant took the steps that they needed to take to make sure that the issue was resolved. And so that issue, that judgment, is no longer allowed to be used against them. We talk about it in terms of, sometimes people talk about it in terms of criminal records, giving people a second chance. The same thing goes for these types of eviction judgments. Tenants who did get a judgment, but then followed through with what they said they were going to do, those tenants get a second chance here, and they don't have that judgment continuously being used against them and denying their applications. A judgment that's more than 4 years old. A lot can happen in 4 years. There's a lot of changes in people's lives and circumstances. A judgment that's more than 4 years old is no longer applicable when landlords are considering a tenant's application. And then finally, a case that's filed during the pandemic. I mean, too many people during the pandemic and still ongoing have struggled to make ends meet. They're doing what they can to access, the resources that are made available through the government, but there's still an understanding that no judgment that occurs to a family during that initial period of the pandemic, March 2020 to September 2021, should be used against a client, with the caveat that if it was a case involving violent or criminal activity, then it can be. But for the most part, those judgments cannot be used against a tenant in their applications.
Yeah, I think it's worth reiterating that for the people who have been struggling with the pandemic, right now there are about 60,000 rental assistance applications. So if you consider those each cases that would end up in municipal court just on the basis of non-payment of rent, those individuals are protected as they probably next year or in the future go to look for new rental properties. Those cases, if they are filed, won't be held against them. So I'm tossing it back to you, Holly.
Thank you, Kadeem. So Say I'm a tenant and I had an eviction case, but one of those criteria applies to me. The case was withdrawn or I won in court, but I get denied anyway. And the document the potential landlord gives me says that I had an eviction case, and that's that. What should I do?
I can actually take this, Rashida, unless you want to jump in. If you go back a slide, I think that this slide helps with the nuts and bolts. But basically, there's three kind of things that you'd want to present to that landlord when you're asking them to reconsider their denial. And Rashida covered it, and I just want to kind of reiterate these three because I think having them up on the screen is really helpful. If your report was inaccurate, or if your denial violated this law, or if you have mitigating circumstances. Those are the three reasons why you'd go to your landlord and you say, look, here's some evidence. Here's evidence that the report was wrong. Here's evidence that you actually weren't allowed to deny me my application because that judgment is 6 years old, right? That's outside the window. You're not allowed to deny that application. Or that last one, I think it's great to point out what these mitigating circumstances are, like a history of on-time payments. Say you had a judgment in 2016, 2017, but you now have a history of 2 years, 3 years of on-time payments. I think that's really valid mitigating circumstances you should be able to present to that landlord and say, look, things have changed. And then, Rashida, do you want to cover the actual actions that the tenant could take? Because I think that's really important in case the landlord's really not responsive.
Absolutely. So yeah, so if you go through all of that process, you bring back all of that information, you're still denied. If you believe that you're being denied on a basis of criteria that the landlord should not be using, you do have under this law, what is called a private right of action. So that means that you can go and file in a court of proper jurisdiction in Philadelphia. That would likely be the Court of Common Pleas, where you can go and file this, or you may be able to also file it in small claims court. But if the landlord violated any part of this ordinance, you can sue them, and there is a $2,000 fine per violation. Also, again, part of this law is meant to deal with the issue of discrimination. So if you believe that, like in the first place, right, you did not get uniform screening criteria, that the prospective landlord gave you a different set of criteria or utilized a different set of criteria to screen your application than what they should have used, and you also can file a complaint with the Philadelphia Commission on Human Relations, who may investigate the landlord for housing violations and other discriminatory behavior. So those are your two remedies in the case that you feel the landlord is violating the Renters Access Act.
Thank you both. So for tenants who are looking at this now, but maybe not applying for new housing for 6 or 8 months from now, where can they go in the future to remember all this, get resources, remind themselves of their rights?
So folks can visit phillytenant.org. David and other folks on our team have created articles as well as flyers that you can share with other people. There's a PDF version of that flyer that you could download if you wanted to share it with others or take it with you while you're going to apply, and just, to remind the landlord of the new law. Not something that you have to do, right? But some folks may find that helpful. There is also, from the Philadelphia Commission on Human Relations, a Renters Access Act tenant screening guidelines. And so you can also visit that site. It's a very comprehensive guide that talks about what the landlord's obligations are under the law, as well as what the tenant's rights and obligations are under the new law. So those are the couple of places that you can go. And then you can also call us. You can contact the Philadelphia Eviction Prevention Project at 267-443-2500. So if there's questions that come up, that line will connect you to CLS. It will connect you to TURN, as well as other legal organizations that may be able to answer questions about this if you do have additional questions.
I'd like to chime in too. Rashida, when we were talking about this law, you made a really good point that in some ways it's not about having to go to court and sue the landlord because they didn't give you something, so on and so forth. It's really about fostering communication between the applicant and the landlord so that they're really talking as human beings, talking as individuals, and really looking at the situation fairly. And I just thought that was a really important thing to point out. This law is not, the perfect law. There is no such thing. And it's very hard to necessarily legislate this type of decision making. But at the same time, I think that communication is really lacking or was before this law went into effect. And as more landlords are becoming aware of this law and beginning to follow these rules, I think it's going to just really help a lot of tenants have that conversation. Like, I know you're denying my application, but here's the thing that you're not considering.
Yeah, exactly, David. The law, some laws, right, some of the aims are punishment and things like that, right? But this law, the goals of it are really about education. It's about transparency. It's about having, as David said, open communication around this process and people knowing what to expect when they walk into a situation. And so just like if you were a person going to buy a new car or going to open a bank account, right? Like you have an expectation around what it is that you need in order to do that. And so this is the same thing. And this is about people's living situations and lives, right? And so knowing before you rent what to expect, right? And it also makes the process more efficient, hopefully for the landlord as well. So that people, they're using the same criteria for each person. There's a standard practice and approach for this, right? Because as I pointed out earlier, because eviction records have a disproportionate impact on certain communities, you may be committing this discrimination without even meaning to, right? By having certain kinds of policies that impact certain kind of people over others. And so this law is really about that. It's really about transparency, communication, opening up a process and educating people on the proper way to approach that process and fairness for everyone.
So before we begin to wrap up, I know that the PowerPoint contains some examples of scenarios that people may find themselves in. If we want to take a minute or two to kind of look at those and see what we don't actually have examples, which is totally fine. My bad on that. But I think the conversation that Rashida and David just had is like super important to point out. This law not only creates a space for conversation, but it sets the expectation that a tenant sees, like when they approach, like everyone needs housing. So when you approach a landlord and you're looking to rent a property, you know beforehand what mitigating evidence I need to submit if there's something on my record that pops up, because I just met someone today who saw a judgment that had been paid off 7 years ago that is still showing as outstanding on their credit report. They haven't lived there in a very long time. The landlord is no longer the same landlord. And this is something that they will be able to track down either a bank statement or some proof that it's been paid off, and both resolve the issue with their landlord, but also prevent prospective landlords from dinging them or scoring them negatively by considering information that one is too old and also is incorrect just based on what they've done. So this really creates that safe space where landlords and tenants can have this conversation. And it also it attacks the systemic issues of who is being impacted by eviction filings and illegal lockouts and all of these other court processes in a very clear way. It lets you know straight up what you're dealing with as you walk in the door, and you can decide whether or not you want to apply based on a landlord screening criteria, because those application fees really do add up. And sometimes you pay an application fee and then a separate fee for your criminal record screening that landlords may charge. So it can be a lot of money to invest without knowing what you're going to be facing in the process. So at this point, any closing thoughts about this super exciting piece of legislation? I just want to make sure that we shout out Council Member Kendra Brooks, who kind of shepherded this legislation to City Council. It was a major lift, and we are so happy that we got to this point, and the tenants in Philadelphia have this protection that they can officially begin to enforce as of a few days ago, but it's live now. You can use it, learn what your protections are. I'm going to throw it back to David or Rashida for any final thoughts.
No, I think you covered it. I also want to shout out to the Eviction Records Coalition and many of the people who are part of that coalition who are impacted by Eviction Records, who actually went to city council members and said, hey, we need something to address this, whether it's ceiling or something like it. But particularly people who have been evicted through no fault of their own, through mass evictions and other forms of displacement where they incur these eviction records and really had no choice in the outcome of that. And so I think the power of people who are impacted being at the table and being centered in the conversation and contributing to the vision of what this would become also is what made it successful and what helped it to move, and as well as the amazing work by Kendra Brooks. And if folks are interested in connecting with that coalition, also visit us at phillytenant.org. There's a section on phillytenant.org that talks about our advocacy work, and there's ways that you can get plugged in if you would like to join a coalition or in some other ways be a part of some of the efforts that we're doing around systemic advocacy.
And I just want to thank you, Holly and Kadeem, and everyone who's watching right now. Thank you for the opportunity to share with you some information about this exciting new law. And as you do have questions, feel free to reach out.
Thanks, David. And also thank you, Holly, for hosting. I know it's a major lift to be here and have this conversation. I just want to also thank the people who join us every time we come on your screens to have these tenant-focused conversations. It's always great to be with you and share updates as they happen in the city of Philadelphia. We are working actively on finding a way to come back into your homes, living rooms, cell phones, wherever people do this more regularly. So look out for more content from us in the future. But thank you for joining us for this presentation, and hopefully you were able to use the Renters Access Act, or at least give someone information that allows them to use the Renters Access Act. Of course, it's available at fittingtenant.org. There are lots of other resources there for every scenario that you could find yourself in as a tenant, or even a prospective landlord just wanting to know, how do I make sure that I stay on the up and up? So thank you, and we will see you soon. Rashida has a statement.
Yeah, so I just went on a Facebook page and saw a question that had came in. Someone asked, are landlords required to return rejections for all applications they receive? So I just wanted to address that question really quick. It's not all applications that you've received, it's all applications that you've screened. So if you've screened that application for admission, then that is when you are obligated to send a rejection letter to that tenant. It's not for every single application. So if you get 500 applications, you only screen the first 10. Those are the first 10 that you are responsible for providing that rejection letter to.
Yeah, I think that's a very important distinction. And you can think about it as to when you initiate that credit check, or you get a document from someone else as a landlord and you say, okay, this person isn't qualified because of this reason. That's the point where you're required to let them know what that reasoning is, to the extent that you rely on some sort of information to reject them. But thank you all for being here. We will have a follow-up conversation very soon. And thank you for everyone for joining us. Have a wonderful day.